Carol McGrew. I am the Unit 4 facilitator for the We the People National Finals. In a moment, I will have the judges introduce themselves, followed by the students, and then we will begin the hearing. Students will deliver a 4-minute prepared statement, followed by 8 minutes of judges' questions. My microphone will be muted during the hearing, and I will hold up the 1 minute and the time is up question. At the conclusion of the hearing, judges will give brief feedback to teams, and then we will conclude. All right, so judges, you may begin introducing yourselves.
Good afternoon, everyone. My name is Zach Eastburn. I'm an attorney in Madison, Wisconsin. Happy to be here.
Congratulations to you for your participation here today. My name is Tom Tinder, and I'm an attorney from Charleston, West Virginia.
And I'm Robert Diane. I teach American government at the University of Evansville.
Good afternoon. We're Foothill High School's Unit 4, representing the state of California and the city of Pleasanton. My name is Nick Jang.
My name is Subha Khan.
And my name is Jocelyn Tao. We'd like to thank the judges, the audience, and the timekeeper for being here today. And we'd like to introduce our coaches, Mr. McBride, Mr. Dedamore, and Mr. Constantellos.
Good afternoon, and thank you for that introduction. Today we'll be doing question 1. So I will read the question, and then you guys can begin your opening statement. Question 1 says, and I quote, "It would be inconsistent with the constitutional separation of the executive and legislative powers to let the prerogative pardon power be exercised by the latter," end quote. What were the framers' reasons for giving the president the pardon power, and do you agree or disagree with them? Relatedly, according to the framer James Wilson, if the president abuses the pardon power, he can be impeached and prosecuted. Do you agree with Wilson? Why or why not? And finally, in your opinion, what constitutes high crimes and misdemeanors? You may begin.
While often overlooked, the presidential pardon in Article 2, Section 2 is one of the most sweeping powers granted by the framers. We agree with the framers' 2 reasons for handing sole authority to the president. First, they designed the pardon after what they saw as a strong system under English common law. Second, they believed that granting Congress the pardon would violate the separation of powers and lead to an ineffective process of clemency.
We feel the pardon power's proper uses are for reconciliation and to prevent justice from becoming too cruel. William Blackstone, a major commentator on the common law, endorsed the king's prerogative to grant mercy, and early presidents used the pardon in similar ways. President Washington pardoned participants of the Whiskey Rebellion to forgive alienated portions of the country, while President Lincoln granted amnesty to thousands of ex-Confederates.
The framers largely agreed that Congress was ill-suited to wield the pardon power. Rufus King felt that the House was too controlled by the whims of the people, and George Mason believed that the Senate already had too much power. We further argue that giving the body that creates laws, Congress, the power to pardon and therefore judge individuals infringes upon the separation of powers. Thus, the president is the best choice to exercise the pardon power alone.
At the same time, the open nature of this power invites instances of abuse as foreseen at the Constitutional Convention. When the president's ability to pardon cases of treason was questioned, Wilson presumed impeachment would check a president who committed treason and pardon those involved in the crime.
We disagree with Wilson for 2 reasons. First, impeachment fails to be a viable check when the pardon power is abused, which we interpret to be when the president is motivated by private interests. According to the Department of Justice, presidents tend to withhold pardons until right before they leave office. Consequently, if they do abuse the pardon power in those last days, impeachment holds little weight because either way, they will no longer hold office soon.
Second, we argue that impeachment overall has become an ineffectual tool due to excessive partisanship. Fundamentally, impeachment is a political institution, as Hamilton acknowledges in Federalist 65. However, partisanship has made impeachment a futile tool. In fact, no president has ever been convicted. In 2021, Congress failed to convict former President Trump for his role in the insurrection due to the support of Senate Republicans.
Historically, there has been no concrete definition of high crimes and misdemeanors. The framers viewed impeachment to be a political remedy and intentionally left the decision of interpretation up to Congress. We agree the standard should remain undefined to keep with the times, but propose two guiding principles drawn from history.
First principle that should justify impeachment is if a public officer no longer faithfully executes his or her duties to office. For instance, in 1862, Judge Humphrey was impeached and convicted for refusing to hold court and waging war against the government. His actions clearly impeded on his ability to faithfully execute his duties.
The second principle is when public officers use their authority in a way that is motivated by their interests as private citizens. In 2010, Judge Porteous Jr. was impeached on the charges of accepting bribes and removed from office for using his authority for personal ends.
On the other hand, President Bill Clinton was impeached for lying under oath to a federal grand jury and obstruction of justice. However, we would argue that he was wrongfully impeached because while lying under oath is unacceptable, the personal nature of his underlying crime was not a violation of his official duties. Ultimately, impeachment was never designed to be used offhandedly, but rather only for egregious offenses. Thank you.
Thank you. So I understand from your presentation that impeachment is ineffective, and the reason that you state that is because presidents have never been convicted. We're talking about presidential impeachment. How do you make impeachment more effective?
I think that if we take inspiration from the impeachment trial we just had, one of the great issues was the huge publicity drawn to the trial, and the issue with that was that Senate Republicans weren't really voting in a way that expressed their true views, and we saw this when even though many of them publicly advocated for the removal of Liz Cheney from the House leadership position, Republicans in a secret ballot vote overwhelmingly kept her in. And so we would argue that one possible reform to the impeachment is to allow a secret ballot vote for impeachment in order to ensure that members are actually voting however what they choose and maintain the integrity of the institution.
I think Congress could also indirectly influence or make impeachment a more weighty tool. If we look at the current Former Presidents Act, it says that an ex-president of the United States cannot receive retirement benefits if they were removed from office by the impeachment process. But if a president were to leave office early, they are still eligible to receive some benefits. So Congress can consider on amending this act and creating conditions based on what pensions a president can receive based on how good his conduct was in office.
If we're talking about other options, theoretically, what about getting the Supreme Court involved with some sort of a trial in front of the court, not a trial in front of the Senate? What's your opinion about that? Why or why not that should be done?
Well, we believe, as Hamilton put in Federalist 65, that impeachment is a trial of public men. And the framers wholeheartedly realized that impeachment was a political remedy to a political problem. And the Supreme Court largely has served as an apolitical branch of our government. And we believe that the Supreme Court getting involved would violate the political questions doctrine, and they would not be able to get involved.
And that's actually what happened in 1993 in the case Walter Nixon v. United States. The Supreme Court said that the impeachment trial, the question about Judge Walter Nixon's impeachment trial, was out of the question for the court because it constituted a political doctrine, and they used that the reasoning that my unit mate just said from Hamilton.
Thank you.
I was intrigued by what you had to say about the strong case against allowing the legislature to be involved in any way with the pardon process. But I'm wondering how that squares with all of the other powers that are shared with the Senate, for example, under advice and consent. Why is the Senate having a say in pardons a violation of the separation of powers, but it's not so in the case of treaty ratification, for example?
Right. The framers, when actually creating the Constitution, the idea of president sharing the power with the Senate was actually brought up. But in this case, the framers were worried that it would make the legislature too powerful, because at that time, the Senate was viewed as sort of an elite body. And at the same time, the belief was that requiring the Senate to convene and demand a vote would take much too long, and the pardon power would have needed when the pardon power would be needed the most.
I think you make a great point. Presidents rarely have such unchecked unilateral power. For example, their decisions to wage war, make treaties, or appoint public officers usually need to pass through congressional assent. But I think Justice Joseph Story of the Marshall Court made a good observation in that entrusting the pardon power solely to an individual office of chief executive would bring home a closer responsibility by making it so that the scrutiny that they would feel for making such important decisions would be heavier.
Furthermore, in Federalist 51, Madison notes the need for all the branches to serve as or the obligation for all the branches to serve as a check to one another. For the pardon is the executive's way to check the judiciary and the legislature at the same time, because you're essentially able to pardon people who have been convicted by the judiciary under laws that Congress has passed. So if we were to share, like, that's why that the pardon power belongs to the president solely, because that's his check on the other two branches.
So let's talk about that though, because I understand that the pardon power can be a check on the judiciary, but what's the check on the pardon power? And really maybe the other way to ask that question is, can judicial review be a check on the pardon power, or should it be?
I think a current check on the pardon power is that if a president is still in office and grants a controversial pardon power before election day, the president can possibly be rebuked at the polls. And we saw this with President Gerald Ford, who lost the 1976 election to Jimmy Carter after granting a pardon to former President Richard Nixon.
And in the cases of judicial review, we actually see in United States v. Wilson, 1833, Wilson actually was able to refuse a pardon, and the Supreme Court ruled in favor of Wilson, saying that a president can definitely issue a pardon, but the person can definitely refuse that pardon. So that is also a check on the president's pardon power.
I think that the pardon also falls under a similar issue with impeachment, because the pardon power is a political statement. So when, for example, when President Jefferson pardoned journalists who were convicted under the Alien and Sedition Act, he was expressing a political statement that this act by Congress was unjust and violated the First Amendment. And so if we handed the pardon to a political tool to a body that's supposed to be nonpartisan, that is going to corrupt that institution's integrity.
Should a sitting president be able to pardon himself or herself?
I would agree with Professor James Tushnet of Harvard Law that constitutionally, in Article 2, Section 2, the pardon power does not have that many checks constitutionally, because it's given in a very sweeping terms in the Constitution. And thus, constitutionally, I believe, and I would agree with this professor, that there is no real constitutional check on the president being able to self-pardon.
I think that from a constitutional point of view, there are two ways in which you can go about that, saying that pardon power should not occur. So I would disagree with my unit mate. And that's about the take care clause in Article 2, Section 4. So first of all, if self-pardons are allowed, that essentially means that a president is able to commit a crime and not be held accountable for it or tried for it, because he can just pardon himself. So he's not taking care of taking care that laws are faithfully executed in that matter. Another violation is that the next president won't be able to prosecute the previous president for his crimes if self-pardons are allowed, and therefore the next president won't be able to faithfully execute his duties either.
And to concur with my unit mate, the framers also believe that self-pardon should not be allowed. If we look at Federalist number 10, James Madison declared that no man is allowed to be a judge in his own cause, because it would, may I finish my thought?
Yep.
His interest would certainly create bias in his judgment and corrupt his integrity.
Wow. Thank you guys very much for that. You can take a breath. Okay, so much to unpack. First of all, I just want to say thank you I think you guys gave a very thorough and well-supported piece of advocacy and argument here. From the beginning of the statement through the question and answers, I think what you guys did, especially I'm going to focus on the question and answer for now, is to any question that we had, you had an ability to really weave in historical examples and constitutional principles and theory in a way that wasn't overbearing and in a way that was persuasive. And that's a fine line, and that takes a lot of skill to do. It's a fine piece of advocacy and something that I can clearly tell that you guys have practiced, but also have not practiced so much that you've killed it. So I really want to commend you for that. The other thing I really would like to just commend you on is you guys disagreed on something, and it was nice to see you guys do that. This whole thing about, and it's specifically the thing that you did disagree on, which was, this whole thing about whether there's a check in the Constitution on the presidential power. And if you look at the language in the Constitution, I would, there is an argument to be made that there is no limit on it, and that is an intellectually honest answer, and not one that I've heard a lot, maybe at all, in this process. So it was nice to see that. But what really drove it home for me was then for someone to say, I disagree. And here's the take care clause and why I think that's implicated here and important. So thank you for that. It's good to see how, I mean, that discussion like makes the issue fully orbed and you see the different sides of it. And so great to see on that. Really overall, excellent job.
Well, I'll just start off by saying that Zach and I immediately gave you a point when you said Blackstone. I mean, that's just great, for us lawyers, for Blackstone's commentary. So, but seriously, you really, really did a very good job starting out with your 4-minute presentation and going right through answering all of our questions. You're not our first group. We've had a number of groups today. And so you, as a judge, the question is the same and you're getting a lot of similar comments and similar questions. Well, you took it to a whole nother level by providing us with new facts, new information, new arguments, new opinions, different opinions. It was just very, very well done. And you understand, as Zach mentioned earlier, what this competition is all about. And it's not about right or wrong answers. There are no right or wrong answers. It's just your opinion, and based upon all of the facts and information and research and knowledge that you have, can you back it up? You just did a very, very good job with that. Congratulations to you. You are all outstanding student leaders who please become outstanding adult leaders for decades into the future. We need people like you as good citizens. Congratulations. Thank you very much. Good luck.
I've got to agree with what's been said already. The examples were rich and they were accurate and appropriate and ranged all across our American history from the beginning to the end. Very impressive, carefully crafted presentation that was backed up in the Q&A with a really thoughtful discussion of the kind of questions that we raised. For example, the political question doctrine, I thought was really expertly answered. You made me think of Richard Nixon, who in an interview with David Frost, they asked him about when he might have broken the law. And he said, when the president does it, it's not against the law. And so his claim was that he couldn't violate the taking care clause because whatever he did was perforce, constitutionally appropriate. But we know what happened to him, and we won't go any further on that. I'm intrigued by your examination of the idea of a secret ballot. And I wish we could think that through some more. You can make a very good case that would liberate senators to vote their conscience. On the other hand, the notion that voting in secret diminishes accountability. And one could make the extended argument that maybe we ought to let them vote in secret on every bill so that they could do the right thing instead of pandering. But on the other hand, gosh, I wouldn't want to live in a world where they were colluding in secret. It's bad enough as it is. But yeah, how do we crack through and get them to make better decisions when they have that weighty job of trying to rule in an impeachment trial? So I appreciate the thoughtfulness you brought to bear, and I'm very, very impressed with what you shared with us. So congratulations.
Great job.
For